A very good afternoon, ladies and gentlemen. Thank you for attending the Jones Day Visiting Professorship on Comparative Commercial Law lecture titled Arbitration, Arbitrators at the Administration of Justice. Time to make the connection. My name is Patrina, and I'm your MC for today. The Honourable Jeffrey Ma, former Chief Justice of the Hong Kong Court of Final Appeal, the Honourable Justice Kannan Ramesh, Judge of the Appellate Division, Supreme Court of Singapore, Mr. Zachary Sharpe, Partner of Jones Day Singapore, Dr. Michael Huang, Honourable Judges, distinguished guests, ladies and gentlemen. On behalf of the E.W. Barker Centre for Law and Business, thank you for joining us today for the Jones Day Visiting Professorship on Comparative Commercial Law lecture. To begin today's program, we would like to invite Mr. Zachary Sharpe of Jones Day Singapore to present his welcome remarks. Mr. Sharpe, please.
Good afternoon, everybody. Thank you for braving the rain to be here today. The Honourable Jeffrey Ma, guest of honor, the Honourable Justice Kannan Ramesh, Dr. Huang, distinguished guests, ladies and gentlemen. Thank you all for attending the session today. This is the professorial lecture by the Honourable Jeffrey Ma, the Jones Day Visiting Professor on Comparative Commercial Law. The Jones Day Visiting Professorship on Comparative Commercial Law and the Jones Day Visiting Professorship on the Rule of Law in Asia were established at NUS Law through the generous endowment of US $2 million from the Jones Day Foundation. Through these endowed visiting professorships, NUS Law is able to bring leading scholars and practitioners to Singapore with deep knowledge and extensive experience and to engage with and enrich our students, faculty, the legal profession, and the wider legal community here in Singapore. Our speaker today, the Honourable Jeffrey Ma, is a prominent figure in Hong Kong's legal landscape. Born in January of 1956, Jeffrey Ma first practiced as a barrister in Hong Kong and was later appointed as Queen's Counsel and Senior Counsel. He also practiced as an advocate and solicitor in Singapore. He then joined the Hong Kong judiciary as a judge of the Court of First Instance in 2001. He was subsequently appointed as Chief Justice of the Hong Kong Court of Final Appeal, where he served from 2010 to 2021. During his tenure, he presided over several significant cases concerning constitutional issues, civil liberties, all of which have contributed greatly to the development of the rule of law in this region. After retiring as Chief Justice in 2021, he continued to serve in the legal profession. He's currently an arbitrator and mediator in Temple Chambers in Hong Kong, David Chong Law Corporation in Singapore, and Brickcourt Chambers in London. He's also on the SIC panel of arbitrators, the HKIC panel of arbitrators, and the HKIC panel of mediators. His scholarly pursuits include serving as the editor-in-chief of the first and fifth editions of the book Arbitration in Hong Kong, A Practical Guide, as well as being a member of the advisory board of the Commercial Law Center of the University of Oxford, and patron of the Bingham Center for the Rule of Law. He is an honorary bencher of Gray's Inn and Middle Temple, and is an honorary professor in the University of Hong Kong and the Chinese University of Hong Kong, an honorary chair and professor of the Law School of the University of Birmingham. I also heard today in the remarks from other people as they were coming in to greet Justice Ma that he's one of the funniest people to sit on the bench. So we're very, very delighted to welcome him here today, and we look forward to listening to his profound insights this evening on the question of how arbitration, arbitrators, and the administration of justice are connected. Thank you very much.
Thank you, Mr. Sharpe. We now invite our distinguished guest of honor, Justice Kannan Ramesh, on stage to deliver his speech. Justice Kannan, please.
The Honourable Jeffrey Ma, King's Counsel and Senior Counsel, Professor Tan Cheng Han, Mr. Zachary Sharpe, distinguished guests, ladies and gentlemen, a very good evening. It is a privilege to be invited to deliver the opening address at this year's NUS Law Jones Day lecture. This year's lecture is particularly special for me personally, as a Jones Day visiting professor on comparative commercial law for this year is a friend and a very special man. I am, of course, referring to Chief Justice Ma. Mr. Sharpe has given an excellent overview of Chief Justice Ma's illustrious career. His Honor is an iconic jurist. His list of accomplishments is long. His mark on the legal landscape indelible. But Chief Justice Ma is also special for another reason. He's a wonderful man, warm and generous. And let me share a personal anecdote. His Honor was one of the first foreign Chief Justices I met after my elevation. It was October 2016. I was part of a delegation led by Chief Justice Sundaresh Menon to Hong Kong for the 5th Judicial Seminar on Commercial Litigation. I don't know whether Chief Justice Ma remembers it. Chief Justice Ma was our host. The seminar was a closed-door gathering of Chief Justices and senior judges from leading common law and civil law jurisdictions to debate difficult issues of commercial law. I was presenting a paper. Unsurprisingly, there was more than a touch of trepidation. Typhoon Haima, a Category 8 typhoon which threatened to wreak havoc on Hong Kong at that time, added to my unease. But Typhoon Haima had to contend with Chief Justice Ma. His Honor said we must come, and we should leave the typhoon to him. We diligently departed for Hong Kong. One of the first things that Chief Justice Ma did was to generously invite Justice Belinda Ang and me for tea and cookies at his chambers in the magnificent Court of Final Appeal building. When we met, the Chief Justice set me at ease straight away. His Honor's wit is legendary, and Justice Ang and I were grateful beneficiaries. Introductions to his colleagues in the Court of Final Appeal and a personal tour of the building followed tea. The seminar was the next day, and after I completed my presentation, the Chief Justice made it a point to search me out and congratulate. That is the mark of the man. I've not forgotten his gesture. I want to share 2 pieces of advice he gave me. He said that when hearing a difficult and highly charged case, a judge should not feel the weight of the world on his shoulders. It was actually very simple. Just do the right thing. He also said that when writing judgments, always remember that it is more difficult to write a short judgment than a long one. I've done my best to follow his advice. This evening, Chief Justice Ma will speak on the relationship between arbitration and the administration of justice. This is a hot-button topic, and I can think of no better person to speak on the subject. But allow me to say a few words on this important topic. The rise of arbitration in the past few decades have been stratospheric. I illustrate with 2 examples. First, the Singapore International Arbitration Center handled 357 cases in 2022, but just in the first quarter of 2023 alone, it handled 332 cases. To put this in context, in 2002, the SIAC handled a mere 64 cases. Second, the total value of the claims administered by the Hong Kong International Arbitration Center in 2023 was $11.1 billion US dollars. This was an almost 3-fold increase from 2022 when it was $4.7 billion US dollars. Arbitration is therefore a resounding success, and its popularity is due to several reasons. An oft-cited reason is the autonomy of the court's parties to choose the governing law, the seat, and the tribunal. It is thought that if the parties are invested in the process of determining their dispute resolution mechanism, they are more likely to comply with the decision that is rendered, which in turn promotes the administration of justice. Confidentiality of the arbitral process is another reason that is frequently offered, but confidentiality is not without its shortcomings. The decision of the High Court of England and Wales in the Federal Republic of Nigeria and Process and Industrial Development Limited, or Nigerian PNID, handed down in October 2023, illustrates this. There, the court allowed Nigeria's challenge to an arbitral award under Section 68 of the UK Arbitration Act of 1996 on the ground that the award had been procured by fraud. The facts of the case are compelling and have been described as most, and I quote, remarkable because of the scale of impropriety during the arbitration proceedings. The dispute arose out of a 20-year gas supply and processing agreement that was entered into between Nigeria and Process and Industrial Development Limited, or PID for short. The parties brought the dispute to arbitration, and the tribunal issued its final award ordering Nigeria to pay PID US $6.6 billion in damages and additional interest. By the time the court issued its decision some 6 years later, this sum had ballooned to US $11 billion. The court found that PID had knowingly provided false evidence to the tribunal, persisted in its bribery of a legal director of Nigeria, and improperly retained Nigeria's internal documents. Unsurprisingly, the court held that PID's conduct caused substantial injustice to Nigeria and allowed the challenge to the award. It is fortunate that PID's egregious conduct came to light in the judicial process, but as the court observed, the case has far-reaching consequences for arbitration. In the words of Justice Robin Knowles, who heard the case, and I quote, "Quite apart from the consequences for the parties, the matter touches the reputation of arbitration as a dispute resolution process," unquote. Many important points were discussed in the judgment, but I'll focus on just one: confidentiality of the arbitral process. Confidentiality brings with it limited visibility on what happens in arbitration proceedings. It is more difficult to scrutinize the conduct of the parties and the tribunal where the proceedings are cloaked by confidentiality. This should be contrasted with the court process where open justice permits and encourages scrutiny, which ensures that public confidence in the administration of justice is maintained. It is against this backdrop that the court in Nigeria and PID expressed reservations over the appropriateness of the arbitral process, in particular for disputes like the one before it, where what was at stake was public money representing not an insignificant percentage of a state's GDP or budget. It is therefore perhaps timely to ask the question whether additional safeguards are necessary, and if so, what they should be. The right balance must be struck between the features that make arbitration so attractive and the safeguards that may be necessary to preserve the integrity and ultimately the legitimacy of the arbitral process. Ignoring the safeguards is anathema to the future of arbitration as a viable dispute resolution mechanism. I've raised one example, and I'm sure Chief Justice Ma will have many more to share. And like you, I'm eagerly looking forward to hearing from him this evening. I would like to express my deep gratitude to Chief Justice Ma for taking the time to make the address this evening. Please join me in warmly welcoming His Honor, Chief Justice Jeffrey Ma. Thank you.
Justice Kannan, Sharpe, distinguished guests, members of the faculty, ladies and gentlemen, it's a great pleasure to be here. I thank Jones Day, I thank NUS for the kind invitation. Especially, I want to greet my old friend, Mr. Michael Huang, who sat there. He reminds me of good times. I was reminded of this good time. I just told Michael that I was yesterday having lunch at the Supreme Court. I was sat next to Justice Judith Prakash. Judith Prakash presided over my last case in Singapore in 2001, before I became a judge in Hong Kong. And in that case was very special. It was special for two reasons. Up until then, I was rather proud of myself, actually, as lawyers are, in thinking I've done rather well in Singapore. I haven't lost a case. As soon as you think that, you lose a case. So it was remarkable for that. The other, which is more remarkable and memorable, I got to cross-examine Michael Huang. Not many people get to do that. And there came a point when Justice Prakash knew that I had to put to Michael that our versions differed, the versions between my client and his erstwhile client and his version. So Justice Prakash was wondering how I was going to put the point. Am I going to say you're lying, or I put it to you're a liar, or what? So I thought, this is very difficult, with Michael Huang. So the best I could do was to say, Mr. Huang, actually, you won't remember this, Michael. I said, Mr. Huang, you and the truth seem to be somewhat, seem to be strangers. At that point, I think Justice Prakash looked at me, and when she looks at you in the way that she does, you stop. I'm afraid I lost that case. No, but I thank NUS, I thank Jones Day, I've said that. In particular, I want to thank Professor Hans Chiu. I want to acknowledge that. And I also want to thank Miss Alicia Cha and her staff and her team for organizing this event. It's not easy organizing events like this, and I wish to acknowledge that. Now, I've long been interested in the conundrum suggested in the title of this address, the link between arbitration and the administration of justice, and the question of whether there should be one. One doesn't often hear or read about this link. I think the most recent I've heard is actually from Justice Kannan. Most stakeholders are quite content to keep the two separate and confine the common ground to a mere acceptance that ultimately both involve the business of dispensing justice, and then leave the debate there. Other than the dialogue at this quite superficial level, the two go their separate ways. It is usual then to treat arbitration in a special parallel in a universe of its own. However, it must be universally accepted now that arbitration is very much a major player in dispute resolution. Indeed, it was recently remarked to me that it is now probably the default means of dispute resolution, more so than the courts. Yeah, I'm talking about commercial disputes, of course. So why should the arbitral process not be treated as part of the administration of justice? I think it clearly is, and I've long maintained this belief. There are, however, practical consequences involved. This is the discussion I wish to touch upon this evening. Why, you may well think, should we be coy about establishing this link at all? In somewhat crude terms, what's the big deal against having this link? The big deal is that once the link is made, those features which are inherent in the concept of the administration of justice then become arguably a part of arbitration as well. An important facet which I want to discuss in a little more detail, owing to its critical importance to the administration of justice, is the concept of duties owed to the court. Should there be equivalent duties owed to an arbitral tribunal? In discussing these matters, I wish to make it clear that I'm dealing with the position in common law jurisdictions. I'm most familiar with Hong Kong, to an extent Singapore. I'm not too familiar with the position in civil jurisdictions. Now, I start saying a little about my own experience in arbitration and in the administration of justice, trying to establish my credentials to talk about this. I practiced in arbitration during my days as a barrister, wrote a number of judgments about arbitration when I was a judge. I was in the working party which made recommendations for what became known as the civil justice reform in Hong Kong, the CJR, similar to the Wolf and Jackson reforms in the United Kingdom. I was tasked with implementing the CJR in Hong Kong when I was Chief Judge of the High Court. As part of CJR, we had to look closely at the link between arbitration and the administration of justice. Later, as Chief Justice, I continued my interest in this link. Following my retirement from the bench, as has been said, I spend some, not all of my time, some of my time as an arbitrator. Rest of the time, I watch football or cricket. And I've mentioned this before, it is important to know which team the audience supports. My team doesn't do so well these days. It's Manchester United. Now, what are the competing views? Those who take a parallel universe view of arbitration point to a number of factors which I accept are attractive, if not compelling. Let's identify some of these main facts, which Justice Kannan has already gone through some of them. First, history. The development of arbitration can tellingly be seen in the way it has historically been treated under statute. From the almost begrudging acceptance in the early days as a viable alternative means of dispute resolution, in which basically the courts retained substantial control over the arbitral process, and appeals to the courts from arbitral awards were similar to appeals from court decisions, we arrive at the present day a position in which recourse to the courts is very limited, certainly no appeals, and which phrases like the autonomy of the arbitral process, one-stop shopping more readily come to mind. Secondly, party autonomy. The point of arbitration, this being its fundamental characteristic, is that the parties to arbitration agreements have chosen arbitration as their preferred and exclusive forum for the resolution of their usually commercial disputes. Furthermore, they choose a forum which is private. This being their contractual choice, and one that is recognized by statute, many arbitration statutes expressly refer to party autonomy and the confidential nature of arbitration, and indeed also recognized by everyone else as a viable, acceptable, and established form of dispute resolution. Why then, it is rhetorically asked, should it be linked again to what goes on in the courts as part of their administration of justice? Thirdly, unique procedures. This point follows from the previous one. Arbitration involves procedures that are particular to it, quite apart from the individual tailor-made directions that are made in arbitrations, the ubiquitous PO1 or Redfern schedules. The individual rules of governing bodies such as SIAC, HEIAC, the ICC, and so on, have unique features. And of course, the laws governing arbitrations in the applicable seat of arbitration, these can vary, they're also unique and differ from place to place. All this emphasizes the uniqueness of arbitration. Most would argue the clock simply cannot now be turned back. Against these factors supporting the independence of arbitration, the parallel universe view, as I've referred to it, what are the arguments that seek to connect arbitration as a dispute resolution mechanism to the administration of justice? That they should be seen to operate together, because overall the objective is to enable a tribunal to make a just and fair determination of disputes. This is surely the same, whether in arbitrations or in the courts. These arguments, paradoxically, use the same factors as the pro-arbitration, the parallel universe ones. So let's go through them again. First, history. It is obviously correct to say that over the years, statute law has made the courts more hands-off than before. However, it is necessary to delve a little deeper into the interface between arbitration and the courts. Significantly, statute has not allowed the courts to let go completely. The involvement of the courts in arbitration remains important. The role of the courts has not, as is sometimes remarked, been reduced to merely being support for arbitration. There is a clear supervisory responsibility as well. Take an example, the enforcement of arbitral awards. Here, although the grounds for refusal to enforce an award are narrow, admittedly much narrower than before, if something has gone wrong fundamentally so that there is a denial of justice, denial of basic notions of justice, the courts will very likely step in. Justice Kannan has already referred to a well-known case, recent case in that respect. Another example of is the power of the courts to review decisions of an arbitral tribunal regarding jurisdiction. Secondly, party autonomy. That's the next one. This aspect is often cited as representing the main difference between arbitration and the courts, and this is right as far as it goes. As stated earlier, the parties to an arbitration agreement have chosen to have their disputes resolved privately and exclusively by a tribunal of their nomination, quite the opposite of litigation through the courts in which the proceedings we've just been told, the public domain, there's a system of appeals, and one does not get to choose the judge. And so the conclusion for many is that it must be accepted that resolution through arbitration is fundamentally different to resolution through the courts. In other words, if arbitration is chosen, the parties have signed on for a different system, for better or worse, so the saying goes. There are limits to how far this can be taken. While it must be acknowledged that arbitration does involve a different system in dealing with the resolution of disputes, I do not accept that in opting for arbitration, the parties have opted for anything less than a just and fair resolution of their disputes, any differently than they would be entitled to expect if their disputes were dealt with by the courts. It seems rather odd, to say the least, that in agreeing to go to arbitration, the parties to an arbitration agreement somehow accept that the quality of justice should be inferior. Moreover, parties aside, I would certainly be somewhat alarmed if arbitrators to think that the objective of justice and fairness that they are tasked to deliver is different to the objective of the courts. I've practiced as a barrister, been a judge and an arbitrator. It has never occurred to me that the parties to an arbitration expect the quality of justice to be any different to that in the courts. And once one talks about justice, the administration of justice must surely enter the stage. Unique procedures, that was the third matter. No doubt the applicable procedural rules in arbitration differ, and sometimes even differ quite substantially from those in court proceedings. But this is not to say that the objective of arbitration and court procedures is different. In my view, they are exactly the same. Under Order 3, Rule 1.2 of the Rules of Court in Singapore, the object of the rules of court, they're called ideals, is stated to include fair access to justice, expeditious proceedings, cost-effective work proportionate to the nature of the action, the complexity of the claim, as well as the difficulty of the issues or questions raised, the amount or value of the claim, and the fair and practical results suited to the needs of the parties. I mentioned earlier I was involved in the CJR in Hong Kong. This led to a revision of the rules of court in Hong Kong. One of the more important changes was to spell out the underlying objectives of the rules of court. Much like the ideals in Singapore, they were to increase the cost effectiveness of any practice and procedure to be followed in relation to proceedings, to ensure that the case was dealt with as expeditiously as reasonably practicable, to promote a sense of reasonable proportion and procedural economy in the conduct of proceedings, and to ensure fairness between the parties. These objectives are surely the same underlying those unique features we find in arbitrations. Again, the administration of justice is engaged. In court proceedings, litigation is not treated as a game, where tactics feature prominently. In the earliest case heard by the Court of Final Appeal, not long after the CJR had come into effect, the Court of Final Appeal said this. Rather, I said this, but it's really a judgment of the court. Critical to the success of the CJR and its objectives is the realization that litigation is not to be treated as a game, but as a serious legal contest. I've often used this term or phrase in a few judgments. It is borrowed, albeit in another context, from the judgment of Mr. Justice Walton in Rightside Properties and Gray. Now, we must now address this question in the context of arbitrations. Is arbitration being treated sometimes as a game, or do we all now accept that the proper, effective, and just resolution of legal disputes is the priority? In discussing this question, I will take as a useful case study the position of lawyers in the administration of justice. Before doing that, I would like to preface the discussion by a reference to the expectation of justice in any community. It is the minimum expectation to which a community is entitled. This is the true meaning of the concept known as the rule of law and its practical implementation, the administration of justice. I talked about this a couple of days ago, so please excuse me, Justice Kannan, if I repeat myself in this, but it's important. Now, you may all have your personal definition of the term the rule of law. For me, the rule of law has two important connected components. First, the recognition that the law governs not only the often complex interrelationships and interactions between members of the community, both personal and commercial, but also protects those individual rights and freedoms that define the dignity that should be accorded to persons, and this include all persons or entities within the community. This can be expressed as an acknowledgement of the rights of the individual, coupled with the respect for the rights of others in the community. Secondly, the rule of law requires an independent judiciary to enforce the law. I've often used this definition of the rule of law to describe the work of the courts, often as a prelude to a discussion to the administration of justice. But I wonder why this does not equally describe the work of arbitrators. Is the commercial community which enters into arbitration agreements not entitled to expect the same standard of justice as the rest of the community? An understanding of the concept of the rule of law just mentioned has guided me in every facet of my time as a judge and continue to guide me in my work as an arbitrator. It is a reminder to me of fundamentals. Now let's take a closer look at our case study, the role of lawyers in the administration of justice and how all this ties in with arbitration. I start with a short statement that has remained with me throughout my time as Chief Justice in Hong Kong. In a speech delivered by Chief Justice Warren, Marilyn Warren, in 2009 at the Judicial Conference of Australia Colloquium, she said this: "The paramountcy of the duty to the court is of the utmost importance to the effective functioning of the legal system. It is imperative that lawyers, clients, and the public understand this. The integrity of the rule of law and the public interest in the proper administration of justice depend on it." Barely hidden in these words were, and still are, the profound concerns regarding the administration of justice. These concerns center on the core activity of the courts to ensure that disputes are not only efficiently and effectively resolved, but that, most important of all, they are resolved justly. The concerns exist because the realities that face those four protagonists mentioned by Chief Justice Warren, the courts, the legal profession, clients, and the public. Overlaps in the interests of these protagonists, of course, exist, but it is useful just to identify just how different these separate interests can be. For the courts, the administration of justice is the key interest. The administration of justice lies essentially in the effective and efficient resolution of disputes to enable justice to be done. For the legal profession, the interests are more complex, involving not just potential conflicts, but in practice, very real ones. The duties owed to the court do conflict with those owed to the client, not to mention the duties to the lawyer himself or to his or her firm. These interests, relatively easy to identify, are nevertheless complex owing to the many grey areas in which they operate. It would be much simpler if lawyers could simply be regarded as businessmen, business persons, or merely carrying on a trade, but this is not so. The interests of the clients of lawyers are purely selfish, the resolution of their dispute in a way most favorable to them. In reality, the client can be regarded as a consumer of legal services in the same way as he is a consumer of products. Yet clients want a system that is just, in other words, a system that will protect and enforce their rights. The public's interest, or the public interest, lies in the effective and just enforcement of rights by an independent and efficient judiciary, committed to the rule of law brought about by the proper administration of justice. What I've just stated surely also applies in the case of arbitrations. There's an additional angle to arbitrations, the financial interests of the arbitrators themselves. This facet, of course, involves more considerations of appearance than reality. It forms no part of an arbitrator's determination of a case to be looking to his or her own financial interests, past, present, or future. However, perceptions are important. This is shown by the very detailed rules and guidance given in relation to the declarations of interest in the appointment of arbitrators, the most recent one being the IBA guidelines, which have been revised. This is not the right occasion to go into detail on this interesting topic in arbitration, but the point of raising it now is to emphasize the necessity of arbitrators being seen to be wholly impartial and independent of not only the parties to a dispute, but also of their lawyers. And so we return to what should be expected of lawyers in the administration of justice. Chief Justice Kannan had very much in mind the need to remind lawyers of the public interest when he gave the valedictory reference in honor of Justice Chow Hik Tin on his honor's retirement. This was in 2017. The Chief Justice spoke about the position of Singapore. Words can apply anywhere. The law is foundational to society, and nowhere is this truer than in our country, which has mapped its path to success on the back of a steadfast commitment to the rule of law. I explained to Justice Chow that these foundational truths might be less obvious to a new generation of Singaporeans, and in particular to young Singapore lawyers. He then made this important observation regarding the practice of law. Practicing our craft in a true spirit of public service and to remind Singaporeans that there's ultimately immense good in the law. I've always liked that turn of phrase. Underlying these statements is clearly the message that the practice of law involves very much the public interest. The concern here is that lawyers will think only in one-dimensional, or at most two-dimensional terms, rather than take sufficiently into account the wider public interest. For lawyers, the interests that have to be served are complex and involve, in practice, not just theoretical conflicts, but very real ones. In the course of litigation, a lawyer will have a number of different interests to take into account. Interests of his or her client, his or her own interests, I've mentioned this, the firm's interests, and so on. Finally, duties to the court. Now, at some stage or another in the course of proceedings, some or even all of these interests may collide with one another. It is easy to answer the question, in theory, of which interest prevails, as I shall discuss presently. The duties owed to the court override all others. However, in practice, one can be forgiven for believing that sometimes thought is given to only some of these interests at the expense of other interests. As I said before, the law is no doubt regarded by many as a business, and it would be far simpler for all concerned if lawyers were to be seen as only business persons. Now, at this point, I'd like to take a slight diversion to remind ourselves of the system of law in which we practice and add some historical color to it as well. The system of law here in Singapore, in my home, Hong Kong, is an adversarial one, and this is traceable to the common law heritage which we know to have originated in England. The adversarial system is basically also the position as far as arbitrations are concerned. The system is one that places the responsibility on the parties themselves, in reality on the lawyers, to present the necessary materials before the tribunal to enable it to determine the disputes between them. It is clear, therefore, then, that in order to facilitate the determination of disputes, much depends on the lawyers who act for the parties, and in particular, on their integrity. By contrast, in civil jurisdictions, classically based on the Roman Kannan procedure, which places the responsibility on judges, not just to adjudicate, but also to gather evidence, the role of the lawyers and the nature of their duties are quite different. Such systems, the so-called inquisitorial system, however, requires substantial staffing of judges. An interesting illustration of the staffing requirements in civil jurisdiction, you can refer to an observation made by Professor John Dawson in his book, The History of Lay Judges. He calculated by the 18th century, France had 5,000 royal judges, whereas the English courts of chancery and common law at that time, no less busy than their French brethren, the judges numbered about 15. Historically, the emergence of the importance of lawyers can be traced back to the traditional shortages of judges in England, particularly in the chancery side. In an interesting paper called Bifurcation, and not bifurcation in arbitration, by the way, Bifurcation and the Bench, the influence of the jury on English conceptions of the judiciary, delivered at the 2007 British Legal History Conference in Oxford, Professor John Langbein observed that in the 19th century, it was baffling, given the volume of cases that had to be dealt with, why there was a severe understaffing of judges. Chancery judges adopted at that time an inquisitorial approach, chancery procedure being based on Roman canon principles. Chancellor had for centuries been religious men, usually a bishop, archbishop, like Sir Thomas More. Professor Langbein said this: what kept Chancery from fulfilling its adjudicative promise is that Chancery never came to grips with the staffing implications of the Roman canon procedures it was employing. Gathering and evaluating witness testimony and documentary evidence is time-consuming work. If you're going to have such a system, you need a large bench. The failure to have adequate staffing in the judiciary coincided with the decline in the significance of jury trials in civil cases. As cases became increasingly complex, it became apparent that juries were unable to determine cases without considerable assistance, or more accurately, intervention from the bench. Juries needed considerable assistance in the law before they could even begin to find the facts, at least the relevant ones, and gradually more issues were seen to be questions of law rather than fact, most notably damages. Judges were even at one stage driven to asking juries to reveal their thinking to the court, and where the judge thought this to be desirable, to send the jury away for deliberation time and time again so that the desired result could be reached. Now, all this led to a noticeable shift from jury to judge in terms of the adjudication process, and it is this shift that led to the emergence of lawyers in the overall administration of justice. No longer could judges, particularly when they were in short supply, adopt any form of inquisitorial procedure The parties, or rather the lawyers, came to be relied on by the courts to place all relevant materials before them in order that the dispute could be properly resolved. As was often the case in the 18th and 19th centuries, it was the courts of chancery which led the way. The work of evidence gathering, perhaps the most time-consuming part of the preparations for a case, encompassing as it does not only the location and proofing of witnesses, but also the discovery process, was left in the hands of the lawyers, not the courts. As Professor Langbein said of this change, as Chancery's subject matter jurisdiction grew, Chancery responded by delegating ever more of its workload, especially evidence gathering. The pattern that emerged was to allow private lawyers acting on behalf of the litigants to control the investigation by drafting interrogatories to be put to witnesses. This departure from the Roman canon model of court-conducted evidence gathering effectively privatized the investigative phase of the adjudicative process. It is this shift that has led to lawyers becoming an integral part of the administration of justice. In relation to court proceedings over the years, whether by statute or by codes of professional ethics, sets of rules have been devised expressly imposing on duties on lawyers to further the administration of justice. Clear example is Singapore. Rule 4 of the Legal Professional Conduct Rules 2015 sets out principles governing the interpretation of those rules. Such principles include a legal practitioner owing a paramount duty to the court, which overrides the duties owed to the client, and also having the duty to discharge honourably and with integrity all of his or her responsibilities to any tribunal before which the legal practitioner appears. The term administration of justice also expressly appears. Rule 11, which deals with conflicts of interest in proceedings before a court or tribunal, states as an interpretive principle that in discharging the duty toward the client, this is subject to the legal practitioner's duties as an officer of the court and to assist the administration of justice. Many professional codes contain references to the duty to uphold the administration of justice. One of the core duties of the United Kingdom's Code of Conduct of the Bar is the duty to the court in the administration of justice. In Australia, the Legal Profession Uniform Conduct Barristers Rules refers to the overriding duty to ensure the efficient administration of justice. New Zealand is no different. It is stated, a lawyer is obliged to uphold the rule of law and to facilitate the administration of justice. These are the rules of conduct and client care for lawyers. In Hong Kong, there is a duty on legal practitioners to assist the court to further the underlying objectives of the court rules. I've always regarded this rule as one of the most significant as representing the new culture introduced by the CJR. The significance lies in the fact that, as far as I know, this was the first time in Hong Kong that the duty owed to the administration of justice was put on a statutory basis. Hitherto, and is still the position, such duties were contained only in judgments and professional codes. Paragraphs 1.1 and 1.2 of the Code of Conduct of the Hong Kong Bar requires barristers to respect and uphold the rule of law, with reference made to the interests of justice and the administration of justice. Rule 2 of the Solicitor's Practice Rules requires solicitors in the course of their practice, not to do in their course of their practice anything to be done on his, or anything to be done on his behalf, anything which compromises or impairs or is likely to impair a solicitor's duty to the court. There are three aspects of the duties owed to the court, more accurate as I prefer to call them, duties owed to the administration of justice, that I wish to elaborate on. conflicts, misleading the tribunal, and positive duties. And you decide for yourselves how far they should apply in the case of arbitrations. Conflicts. When I started practice as a barrister 45 years ago, I was number 125 on the roll of barristers in Hong Kong. There are over 1,600 barristers now in Hong Kong and over 12,000 solicitors. Law schools have trebled, providing law students and producing law students and ultimately lawyers in ever increasing numbers. It's the same in Singapore. Competition is great. Practice promotion, frowned upon not that long ago, is now commonplace and even expected. It can even be regarded, as has been said, to be a constitutional right. Even with the massive growth in financial centers such as Singapore and Hong Kong over the years, and this includes the proliferation of work generated by the financial growth elsewhere in the region, I dare say the volume of work for lawyers perhaps has not quite matched the simple increase in the number of lawyers. But on the whole, legal work is lucrative, and the financial rewards are certainly tempting for most lawyers. I've no concrete figures, but like the United Kingdom, Australia, and New Zealand, legal services have expanded to such an extent that they represent a not insignificant part of the overall economy. Litigation and dispute resolution have grown as part of the expansion of legal services. Lawyers who engage in this part of legal practice are, of course, not immune from the modern pressures of intense competition. Not to put too fine a point on it, as I've earlier mentioned, law has become big business where substantial profits are to be made. Intense competition means for many the dominant position held by the client. As I've described earlier, the client's interest is a straightforward and selfish one, his or her own interests. A lawyer is expected to deliver to the client what he or she wants. If a lawyer is not prepared to go all out, the simple truth is that the client will simply look elsewhere. And this is the rub as far as duties owed to the court are concerned. Many authorities exist to the effect that no conflicts exist between the duties owed to the court and duties owed to the client. The former prevails every time. Statements to this effect have come from the most eminent jurists in the common law world. Chief Justice Mason, namely Chief Justice Mason in Ginarelli against Wraith, Chief Justice Gleeson in Daughter against the Victoria Legal Aid, Lord Reed in Rondell and Worsley. Warnings have been sounded as to the evils of economic self-interest when ethical demands dictated a different course. See here Justice Sandra Day O'Connor in Shapiro against the Kentucky Bar Association. You will know the reiterations of this fundamental principle in Singapore. Yet, as we all know, there is in practice a real conflict at times, or even often, between the interests of the client and the interests of the court. The court is interested in justice overall. The client is interested in justice only for themselves. The lawyer can at times be caught in the middle as to what ought to be the appropriate course. There is nothing necessarily sinister about this. The proper professional course is at all times to bear in mind the duties owed to the court, but within those duties to act in the best interests of the client. There are naturally grey areas, but the lawyer should err on the side of the administration of justice and not sacrifice this ideal in favor of economic considerations. This brings home the proper context in which one must view any discussion of duties owed to the court. As with so many other aspects of the law, different and at times conflicting, but entirely legitimate interests come into play. It is, I would suggest, unsatisfactory to approach the topic of duties owed to the court simply by reference to vague notions of truth and justice. one really has to look into a number of facets of what we understand to be encompassed in these terms: a fair trial, a just resolution of proper disputes, fair and proper representation of the protagonists in a dispute, effective and efficient procedures. Thus viewed, a clearer picture emerges of the administration of justice and the role of lawyers within it. On conflicts, a good summary of the points I've made appears in the judgment or the speech of Lord Hoffman in a case called, well-known case called Arthur Hall against Simons, where the court considered the issue of immunity. Said this under the heading Divided Loyalty: lawyers conducting litigation owe a divided loyalty. They have a duty to their clients, but they may not win by whatever means. They also owe a duty to the court and the administration of justice. They may not mislead the court or allow the judge to take what they know to be a bad point in their favor. They must cite all relevant law, whether for or against their case. They may not make imputations of dishonesty unless they've been given the information to support them. They should not waste time on irrelevancies, even if the client thinks that they're important. Sometimes the performance of these duties to the court may annoy the client. So, it was said, the possibility of a claim for negligence might inhibit a lawyer from acting in accordance with his overriding duty to the court. That would be prejudicial to the administration of justice. The conflict between duties owed to the court and the duty owed to the client has come to be known as the divided loyalty aspect. Now, misleading the court. Many lawyers regard the content of the duty owed to the court as no more than a duty not to mislead. It is true that the majority of duties owed to the court can, on analysis, be classified under this head, such as the duty of disclosure owed to the court, duty not to abuse the court's process, and the duty not to corrupt the administration of justice. The duty not to mislead includes the following important facets. In civil proceedings, there is a duty on a lawyer to ensure full and proper discovery by his or her client. Severe consequences follow where this duty is breached. The theory here ought to be quite simple. There is an obligation to advise the client that disclosure of relevant documents should be made, in particular of documents which are against the client's interests. Yet, it is the latter aspect that in practice can sometimes provide a stumbling block, as increasingly what can be described as ingenious attempts are made to avoid discovery of such documents. There are, of course, built-in and legitimate limitations to the disclosure of relevant documents or facts, LPP, legal professional privilege. Say a little more about discovery later in the context of arbitration, because this is often one of the litmus tests for the applicability of the concept of the administration of justice. The duty not to mislead also includes the obligation to ensure that the court is properly apprised of the relevant law. In other words, the duty to inform the court of relevant statutes or decisions on a point of law. The duty can be a difficult one to fulfill in practice, where, for example, non-binding but persuasive authorities are involved, including authorities from overseas. Now, positive duties. Do the duties owed to the administration of justice go beyond not just misleading the tribunal? In my view, there is an important duty on lawyers to assist the tribunal in the effective and efficient resolution of disputes before it. In a passage that has consistently been followed, as well as cited, Chief Justice Mason said this in Generelli. A barrister's duty to the court epitomizes the fact that the course of litigation depends on the exercise by counsel of an independent discretion or judgment in the conduct and management of a case in which he has an eye not only to his client's success, but also to the speedy and efficient administration of justice. In selecting and limiting the number of witnesses to be called, in deciding what questions will be asked in cross-examination, what topics will be covered in address, what points of law will be raised, counsel exercises an independent judgment so that the time of the court is not taken up unnecessarily, notwithstanding that the client may wish to chase every rabbit down its burrow. The administration of justice in our adversarial system depends in very large measure on the faithful exercise by barristers of this independent judgment in the conduct and management of the case. I've now gone through in some detail the concept of duties owed to the court. Given the objectives behind this concept, directly related as they are to what I've called the administration of justice, one must now face this question. Practicalities aside, is there any reason in principle why the same standards should not apply in arbitral proceedings? After all, is there any reason why the strict standards going to the effectiveness and efficiency of court-determined disputes, why they shouldn't apply equally to arbitrations? The stakes in an arbitration are certainly high enough. Many of the claims are of a commercial value much higher than one often sees in court proceedings. States can be involved, investor-state arbitrations. Matters of significant commercial significance often feature. At present, I see a disconnect between arbitrations and the administration of justice in the context of the courts. The strict standards applicable as far as courts are concerned are far from compulsory or even expected in the case of arbitrations. I use the word expected because in practice, although one does of course see ethical and what I regard as proper professional standards employed by lawyers in arbitrations, occasionally one does not. And it is this that gives rise to concerns. As an arbitrator, when I do not feel confident that I've been given as much assistance by the parties to help resolve the dispute between them efficiently and fairly as I had hoped, there is left a nagging feeling that perhaps more, sometimes even much more, should be required to be done. And this is aggravated by the very real fact that arbitration very often is and expected to be a one-stop forum. As I mentioned before, there's virtually no right of appeal. The pressure in getting it right, not just the first time round, but the only time, is a heavy one indeed. An answer to this may be, well, this is a system that the parties have agreed to when they entered into an arbitration agreement for better or worse. I've used those words before. I've touched upon this. My answer to that is, why should the parties suffer from the system of arbitration being worse in any aspect than the courts? I provide one example of a difficulty which exists in practice, and this relates to discovery. I've already mentioned the aspect of discovery when dealing with duties owed to the court. The duty of the lawyer is to advise the client that it is in particular those documents against the interests of the client which must be disclosed to the other side and a tribunal. Does such a duty exist in arbitrations? How often is such advice given in arbitrations? And what is the advice that is given if the lawyer has actually seen documents which go against the client's interests? I've often informally asked these questions of arbitration practitioners. The answers are interesting and revealing. There are largely two. Some say there is simply no duty to advise the client to disclose such documents. Obviously, the other side, the other party, at the document disclosure stage of the proceedings, makes a request for documents, and the damaging document falls within the specified document or class of documents requested and ordered, then they would have to be disclosed, but not otherwise. Others say that as a matter of practice, they would so advise the client. However, what if the client then refuses or asks the lawyer for details of the legal basis compelling such disclosure? If the lawyer can do no better than to say that it is desirable or professionally desirable to do this, this is unconvincing. Either there is a legal compulsion to disclose or there is not. It is a simple enough question. The client would probably look elsewhere for legal representation if the lawyer cannot provide a compelling answer why such documents would have to be disclosed. It is in situations like this that gives rise to a direct conflict between the practice and arbitrations and what one would think is an integral part of the administration of justice. I posed a question earlier, practicalities aside, is there any reason in principle why the same standards should not apply in arbitral proceedings? If one had a clean slate, there's no reason at all why this link should not be made between arbitration and the administration of justice. But we don't have a clean slate, and instead there are real practical difficulties. These difficulties emanate from the fact that arbitrations are often international and involve lawyers from not only different jurisdictions, but also different systems of law. There is no uniform concept of the administration of justice, or whether the concept of duties owed to the court even exists in different jurisdictions along the same lines as I have described. There is a definite mismatch when lawyers acting for different parties are subject to different ethical rules or duties. The playing field is not a level one at all, and when one side is subject to strict rules, but not the other side, what happens? The IBA guidelines on party representation in international arbitration are inspired by the principle that party representatives should act with integrity and honesty and should not engage in activities designed to produce unnecessary delay or expense, including tactics aimed at obstructing arbitration proceedings. However, those guidelines remain only that, guidelines. They are far from being compulsory. I accept that the practical difficulties are immense, and many of you will think impossible to achieve. I don't have ready answers as to how the practical difficulties can be overcome. It's not my objective today. My hope is to stir some interest and get you thinking along the lines that arbitration is a part, and in my view already an integral part, of the administration of justice. Can we all take it a step further now? I want to thank again NUS and Jones Day. It's an immense honor for me to speak to you today. Thank you.
Chief Justice, I mean, I think you mentioned this, that while lawyers are officers of the court, and we do sort of swear an oath to that in many ways, we don't actually owe duties to the particular arbitral tribunal that we appear before, right? Because that's very much a private process. And therein lies, I suppose, the nub of the problem. Do you think that there are functional substitutes in, for example, the obligation to act as would befit a member of an honourable profession? So that, for example, if I advise my client to act in some way dishonourably, if I would acted somehow as to mislead the tribunal, and that were to emerge, that would actually be a reflection of my not acting in accordance with the ideals of an honourable profession, and could in itself then be a disciplinary offence.
This, as far as courts are concerned, the position is absolutely clear. The question which I've been posing is, why in principle should it also not apply to arbitration? We all know that it doesn't. And my conversations with various arbitration practitioners, the answer is that, well, an honourable profession, as you've described, requires us to do various things, and acting dishonourable may actually lead to sanctions against a lawyer himself or herself. Now, that's a little academic in a way, because the whole process being a private one, and there's always a marked reluctance to report anyone to a professional body. I think this is more apparent than real. Now, if the lawyer were to say to the client, I can't do this because it is dishonorable conduct, the client's going to say, are you actually saying that whatever I want you to do, you won't do because of a sense of honor or dishonor? And that's not really convincing, because I think the client wants to know either I can do it legally or I can't do it legally. Now, in the example I gave, which is the disclosure of a document or documents which are damning to the client, I suppose you can do it indirectly, the disclosure, by saying this, that at some stage during the arbitration, especially of an arbitral tribunal of 3, somebody is going to notice that such a document should exist but hasn't been disclosed. And at some stage, counsel is going to be asked by the arbitral tribunal, actually, does this document exist? Now, then counsel is put in a difficult position of either lying, he's not going to lie, or to make up some excuse and kick it to touch and say, and ah. When it becomes painfully obvious that the document exists, but there is an unwillingness to then disclose it, and that then counts against you ultimately. It's that sort of scenario then you have to tell the client, that's going to be really, that's curtains for you in the arbitration if this comes out. That is why I advise you, you must disclose this document. At the moment, it has to be something along those lines, as opposed to something which is straightforward, consistent with what I call the administration of justice, for this requirement to be compulsory. But it's very hard, because I talked about practicalities, and there are real practical difficulties, because I'm not sure how you can ever get to a stage in international arbitration where there's going to be a code of conduct which applies to all who practice in international arbitration. The IBA guidelines are a good start, but those are just guidelines, not compulsory, and not many people sign up for it. You see in arbitrations IBA rules of evidence being compulsory or referred to, but not guidelines as to ethical behavior.
Thank you, Chief Justice. And in fact, the example you gave was something quite close to my heart, because I remember a case that I did some time ago when it was precisely this situation. I came across a document that seemed to me I ought to disclose, but which had not been disclosed. And, I told the client that I really think you ought to disclose it, because it might well come up. If it does come up, then you might look bad, or the tribunal might ask me, and I would have to give an honest answer. Fortunately for me, it was so late in the day, they didn't have time to sack me. So I managed to run the case after all. But it is a dilemma, I think, that many advocates will face. Might I then now invite, yes, Gary.
Thank you so much for your talk. It's very, very interesting. And notwithstanding the fact that you said you would limit your remark to the common law, but you did mention the differences between the civil law and common law, and you alluded to it. One of the difficulties that even the concept of rule of law is different. Perceived, well, we don't have even the word rule of law in civil law. We use completely different concept. So how, we all agree in principle, and we do have some things we have internationally in almost all the different laws. For example, the right to present your case fully, the right to a fair arbitration. These things that are pretty standard everywhere. But when we ask a national court to tell you what is fair, what's this fair, they tend to replicate their own concept of justice. For example, discovery. Civil law doesn't really have discovery. There is no concept that you have to give something to the other side, nor is there a process where you ask for documents either. It's very rare that the court has the power to do that, but it's very rare. So the idea that not disclosing a document is somehow breaching a duty that you have toward the court or the tribunal is simply not there. So if you choose a seat in a common law jurisdiction, should you accept the common law concept of justice and fairness and rule of law? And if you don't want that, should you go and choose a seat in France or elsewhere where the rule of law concept is different?
That's, of course, one of the problems, that there are different concepts of what rule of law means, or whatever name you call it, different views as to what the administration of justice means. I mean, you can all say that surely it's the same thing. It's all about justice at the end of the day. But we're talking about practicalities here. And you mentioned the practical aspect of discovery, because in many civil law jurisdictions, I know there is no automatic discovery in the same way that we get in common law jurisdictions, even though there's a bit of a retreat against that because of the excesses of discovery. Now, then enter arbitrations where there is always the possibility of making requests for documents, and that is actually one part of the arbitral process, which is often overlooked, because sometimes you get in the ubiquitous procedural order number 1, you don't even have references to document production. There is a requirement that parties must disclose documents they rely on. But that's, I would have thought, you don't need a direction like that, because a party, if you want to win, you're going to put in documents which are in your favor. It's the other part which I'm keen on, which is you better start revealing some documents which are against you or maybe against you. Now, the retreat against discovery, Justice Kannan will know this, there's a bit of a retreat, but I myself see it as a valuable tool. Where documents are relevant, I'm going to be more inclined to order them to be disclosed rather than not. Not irrelevant documents, not documents which generate, which, by the way, there's a well-known, for just a sort of diversion, the excesses of discovery, such that in the old days, when there was just massive discovery, which involves photocopying, lawyers' firms were just joyfully saying that at the end of the discovery process, how many equivalent of BMWs they had managed to photocopy during the discovery process. That was the sort of excesses of discovery that we're talking about. But in dealing with excesses, we then, in a way, the pendulum's swung the other way, so that there's now a marked reluctance to order discovery or even to talk about discovery. And this also fits in with what you were saying, Gary, a civil law jurisdiction who then think, right, everybody's now falling in line, so basically let's forget about discovery. And yet, hidden among all this are duties owed to the court and the administration of justice, I'm not quite sure what the solution now is, except in an arbitration setting, it's in the hands of the arbitrators.
Associate Professor Rebecca Ananian-Welsh from the University of Queensland. I'm really glad I'm visiting and haven't missed this. Thank you, Chief Justice. I have an answer, I guess, to propose, or I'd like your thoughts on, to your question of whether there's a principled reason why the same standards or duties wouldn't apply, and I'm guessing that wouldn't apply with compulsive force in an arbitration. And does that principle arise from state sovereignty? that lawyers owe a duty to courts and may owe a duty then to tribunals or royal commissions or other kinds of bodies as part of the rule of law, because those courts, tribunals, royal commissions represent law and the state in a way that arbiters have separated themselves from. Now, that's not to say the same duties wouldn't serve a very wonderful purpose in the context of an arbitration, and maybe the solution is that arbiters need to be brought into the realm of state sovereignty or tied to it somehow. But is that the principled reason why you can't enforce those same duties on lawyers when they're in an environment separated from state sovereignty? I'd also be really interested if you could comment more on something you mentioned very briefly, which was that there may be a need, perhaps evolving in the future, for arbiters to have protections around their independence in the way that courts do in administering justice. Even fundamental ones around maybe tenure or remuneration and those kinds of things. Do you see that those kind of protections might emerge, or that arbitration might be able to maintain its special spot very separately to courts and different to courts while still being integral to the administration of justice?
What you've highlighted, I mean, in that last point you made, is of course there are vast differences and will always remain vast differences between arbitration and the courts. You mentioned, for example, tenure. Now, tenure is not something anybody mentions in arbitrations. No arbitrator, of course, has tenure or an expectation that that he or she is going to remain on the list of approved arbitrators or even desired arbitrators. I mean, part of the difficulty in this is that it gives. I mentioned this briefly in terms of the sort of conflicts which exist. A lot of people can't get their minds around the fact that arbitrators are paid. And it's a very difficult conceptual argument to get over, because, and it's also a practical problem, not just a conceptual one. The conceptual one, of course, is you're being paid. Right? The practical problem is that it always gives rise to rumors and theories that, I better be nice to the people who instruct me. Because although in theory it's the client who nominates you as an arbitrator, it is always the firm of lawyers that effectively does so. And we all know that in international arbitration, we're just talking about a few firms. This is the case in Hong Kong. I imagine it must be the case in Singapore. If you say, let's say, just take a rough figure, let's say, or actually I'm looking at Michael, 30 firms mainly do arbitrations in Singapore. It's more, I mean, mainly do. I mean, not just the odd one. 50? Is that a fair figure? Let's go for 70, all right, which I think is quite a lot, actually. I don't think it's anywhere near 70 myself, not in Hong Kong anyway. It's the same firms, 70 firms, that get to nominate arbitrators. Now, the right attitude is you don't care whether you get ever nominated again. But that's not the perception. The perception is that you want to get nominated again. And sometimes, because I've had this with lawyers admit this to me, usually when they've had a few drinks, but they admit this to me, that yes, actually, sometimes we ask for the moon in terms of, let's say, or I want 6 months to file my pleadings or something like that, because this is an arbitrator whom we nominate a lot, and he is more rather than less likely to grant us this extension. Now, Michael's looking at me, and of course the right attitude is I don't care whether you continue to instruct me or not, but that is the perception which you have, and that is one of the problems which you have. Now, all this I've been sort of prevaricating because your first question is a little more difficult, which is you suggest a what I call a conceptual reason as to why the same duties don't exist, and you link it with sort of a sort of national a concept. I would not agree with that, because while I think that definitely merits a PhD being given to you, if you did a thesis on it, without a doubt. I mean, however, that's not where I'm approaching it from. I'm approaching it from a very simple basis, which is if the job of a tribunal is the fair determination of a dispute, and in the workings of that tribunal, much is dependent on lawyers, their ability, their integrity, and so on, then while the duties expected are high in relation to courts, why is it not the same for arbitrators? Now, of course, the answer to that, the ready answer to that, is that this is impractical. Now, that is quite right. It is hard to achieve, but that doesn't mean that one can't start thinking about it and then doing something which goes and promotes that state of affairs. Because it's, let's put it this way, arbitration is, how can I best put this? Let's say bad enough because it's private. Nobody knows what's going on. From an administration of justice point of view, because it's in the justice game, to have such a private state of affairs where nobody really knows what's going on, it leaves a slight sour taste in the mouth. How can you best rectify that? Not by publishing awards or by revealing who the parties are. It's done, but it's rather indirectly by looking at what statutes say, because the statute of any given jurisdiction will tell you a lot about the integrity of arbitrations and what is expected, but also by the rules which may govern the conduct or the misconduct of the people who practice within it. In other words, ethical standards. If those are ready for people, readily seen by the world, people would then be more rather than less inclined to have confidence in it from an administration of justice point of view.
We have time for one more question, or in which case I have to assign it to Mr. Michael Hua, arguably Singapore's most distinguished arbitrator.
You can ask the question and answer it yourself, Michael.
When you raise the question of unethical behavior by arbitration counsel, this is a problem that's been around a long time. I've written many articles on this, but nobody listens. The short point is this. If a court becomes aware that a counsel has been guilty of unethical conduct, the court has means of getting the lawyer disciplined in some way or other, right? So I don't know what you do in Hong Kong, but here our judges will, through the registrar, make a complaint to the Law Society or possibly even to the Attorney General, and so on. And so the matter gets policed and dealt with. In arbitration, that doesn't happen, and there are two structural reasons for it. First of all, arbitration tribunals take the general view that they're not there to enforce ethics. They're just there to decide a dispute. And indeed, if they find unethical behavior, they're actually constrained for two practical reasons. The first reason is the rules of all arbitrations generally are confidentiality, and that includes the arbitrators. So if an arbitrator, unless you violate our Serious Crimes Act for money laundering and stuff like that, tribunals can't reveal. The second is another reason which is raised, which is that it makes the arbitration impossible or very difficult to carry on if halfway through the case, the tribunal says, I think counsel has been guilty of some kind of professional misconduct. Now, what do you do about that? You can't just pronounce it in court. You have to then hold a trial within a trial. That's not the function of the tribunal because it interferes with the main purpose of the tribunal, which is to come to a decision. And then even if you had the right to make the report, the confidentiality binds you. So there is no set of arbitration rules of any institution that creates an exception for confidentiality to allow a tribunal or indeed other counsel to make a report about another counsel to anyone. I mean, and that's because there is no motivation in the only people who can change these things overnight, and that is the institutions. And the institutions have resisted calls to say, you should take up the job of ensuring ethical behavior. And if it comes out in an arbitration that takes place under your rules, and it comes to light that a counsel has misbehaved in, say, an ICC arbitration or an SIC arbitration, what is the institution going to do about it? The institutions have no appetite for this. And indeed, it was very interesting, Chief Justice Menon, in I think one of the predecessor lectures in this series some years ago, he raised that question. And at that time, Chief Justice Menon was very influential, and probably still is, on the Chartered Institute of Arbitrators Board. And he was saying that he wanted to get the Institute of Chartered Institute of Arbitrators to create a mechanism for discipline. Now, there actually is a mechanism for discipline within the Institute of Chartered Arbitrators. And it is actually meant for disciplining arbitrators. But a generous interpretation of the rules will extend it to any member of the CIR. And many lawyers are members of the CIR. So the question is whether or not the CIR should take up that role. I understand that subsequently, within the higher councils of the CIR, this was mooted. Chief Justice Menon's proposal was discussed and then not taken up. So unfortunately, that's where we are. So my final sort of plea, modified my article and wrote a shorter version of it and said, look, nobody has got appetite to control it. The simple way is this. All you need to do is to change your institutional rules to allow anyone, well, let's say the tribunal, to make a report, to create another exception to confidentiality, to allow anyone, whether it be the tribunal or participating counsel or even a client, to make a report to the bar counsel of that particular lawyer. So that lawyer will be dealt with under its own professional rules, which also takes care of the question of different standards of ethical conduct.
I guess the question is, do I agree? Which I do agree, because the answer is yes. But you are right in saying that a lot of the institutions don't have an appetite. A lot of places don't have an appetite for this because they see this as directly related to how attractive a place is for arbitration. Because the more barriers you put up, this is seen as a barrier, the worse it is. The impetus for this, I agree with you, can come from institutional rules. The greater impetus comes from the professional bodies, and the even greater impetus comes from statute, and that involves, of course, the state taking an active interest in this. I mean, the fact that there exists the possibility of disciplinary proceedings and so on is enough, I think, to bring about, I think, an increase in standards or a stricter view of one's ethical behavior. I mean, for example, now, I've waxed lyrical, talked a lot about duties owed to the court and so on. In practice, how often do the courts haul counsel up on a breach of duties to the court? Very rarely, I think. Apart from anything else, the courts will only look at the most egregious breaches before it does anything. It's not some sort of thing that happens every day. But it is something worth thinking about, because if you don't think about it, then the matter just remains in abeyance, and your articles then just, don't become reality, which is a pity.
So I think this brings us to the conclusion of our question and answer session. I apologize to the individuals who may have wanted to ask a question but couldn't be accommodated because of the time constraints. I encourage you to engage the Chief Justice after this session is over, because I know that we will have a reception, of which Petrina, I think, will say something about. But before we do this, will you all please join me again in thanking Chief Justice for a wonderful speech this evening?